The federal court has dismissed review applications by 3 prisoners seeking to set aside their whipping sentences, ruling that the punishment is constitutional. In a 2-1 majority decision on Wednesday, Chief Justice 1 Ahmad Farid 1 Salleh and Chief Judge of Sabah and Sarawak Azizah Nawawi formed the majority, while Federal Court Judge Lee Swee Seng dissented. The applicants, Mohammad Helmi Anwar Mohammad Qasim, Kumanan Anthony Vincent and J. Sivachandran, had argued that caning violated their constitutional rights to life and equality before the law under Articles 5 subsection 1 and 8 subsection 1 of the Federal Constitution, and cited the risk of death in reference to a past case involving an inmate. Justice 1 Ahmad said whipping does not fall within the scope of cruel, oppressive, or degrading punishment in the constitutional sense, adding that it does not deprive a person of life in the same manner as the death penalty and therefore does not breach Article 5 subsection 1. He said it is for Parliament to determine the appropriateness of such punishments, and that the judiciary should not substitute its own moral views for legislative policy. He also ruled that the applicants had failed to present medical evidence showing they were unfit to undergo caning or that it would pose a risk of death. In his dissent, Justice Lee held that whipping is unconstitutional as it violates the right to life, dignity, and equal protection under the law, saying the manner in which caning is carried out could result in long-term physical harm, including permanent disability, affecting a prisoner's ability to work and support their family. The 3 applicants were previously sentenced to death for drug trafficking and murder before their sentences were commuted to 30 years imprisonment under the revision of Sentence of Death and Imprisonment for Natural Life Act 2023, along with caning. Mohammad Helmi and Kumanan were each sentenced to 24 strokes of the cane, while Siva Chandran received 12 strokes,